All rise. Appeal in for the 5th District of the State of Florida is now in session. Honorable Vincent D. Torpey Jr., Chief Judge presiding. All persons having business before the court draw near and give attention and you will be heard. And God save the United States of America and the state of Florida and this honorable court. Please be seated.
All right, good afternoon. I've been introduced. Let me introduce you to the balance of the panel. To my right, your left is Judge Sawaya, and on the other side of me is Judge Cohen. We have a criminal case and 2 civil cases this morning. The criminal case will get 15 minutes per side. The civil cases will get 20 minutes per side. I have an amount of time reflected already on the clock for rebuttal. If you want a different amount of time, if you just glance at it, and if you want a different amount of time, let me know what it is, and I'll change the rebuttal time accordingly. If anybody's got any kind of noise-making devices, double-check them for me right now. I'm going to double-check mine and make sure that they're in the silent mode so that the lawyers are not interrupted during their arguments. And with that, we'll proceed with the first case on the docket, DELATORRE versus State. I got 3 minutes of rebuttal time for you. Would you like a different?
5 minutes, Your Honor.
5? Okay.
Yes.
Yes, ma'am.
Good afternoon. My name is Susan Fagan, and I represent Mr. German DELATORRE in this appeal.
Pull that mic down closer to your mouth if you would.
Is that better?
Yeah. That's a
Okay.
little better, thanks.
My name is Susan Fagan, and I represent German DELATORRE in this criminal appeal. I might be calling on the spirit of Steve Jobs to get through this, but in essence, we're talking about the state's failure to have its evidence meet the mark of a knowing possession of the 57 images my client's charged with. As the case law cited in the brief begins to set out the distinctions between a controlled substance possession and the possession at issue in this case, and of course the recent decision of the Florida Supreme Court in Dowse, the state must prove each and every element of the charge. And the heart of this appeal is that the state did not as to each of these counts. They tried through their expert who could not provide the how, who, where, when, and what exactly happened with these images, how they were produced, how they, the various attributes of the individual files and the images in those files that are at issue.
Well, the hard drive was found in his room in a drawer, I think, wasn't it?
That's correct.
And wasn't his name attached to the file where the pornography was located, German?
It was a loose hard drive, yes. They had a...
But you're saying that that is not evidence of him possessing the...
Correct.
Why not?
Because the explanation provided, or actually by the defense witnesses to begin with, of multiple users to all of the equipment found in the bedroom.
We're talking about a hard drive that was found,
Right.
that was taken out of the computer, that was in a drawer in his room, and the
correct.
file in which these pornographic pictures were located had his at least first name on there, right?
Well, as the main...
Were they using that? How were they using that?
They were just using that as a designated user.
How do you use a hard drive in a computer when it's out of the computer, sitting in a drawer inside the man's room?
Well, that's the problem. You have a loose hard drive, and with images from unallocated space, which creates quite additional problems with intermingling of as suggested during the testimony by Mr. Long, he had acknowledged You could have intermingling of files if it's not properly scrubbed, and you have additional problems.
The jury heard all the evidence and testimony, right? I mean, they weren't deprived of anything that you say, you know, that should have been proper evidence. I mean, they heard it all, and they heard the fact that there was his hard drive. It was in his room, had his name on the file. It was located in a drawer in his room, and they heard all that, and they said it was his, right? And
Well,
that he knew that the pornography was on the hard drive, right?
That is the pyramided inference that the state is trying to do. As you look at the Flyer case, and you look at, we're also talking about a laptop also, down by the couch. in
Yeah, I
the
mean, I
living-
was just using the hard drive as an example, because
Right.
I think one of your arguments was, well, there are a lot of other people that were using it. I was wondering, well, how do you use a hard drive that's sitting in a drawer in a desk somewhere inside someone's room, and it's not even in the computer? But
Well, the problem there is, we don't know how that hard drive was used, a loose hard drive. We don't even know if it, Mr. Long testified that he didn't even test if it could be rebooted apart from just the software that he applied, his forensic, in a regular computer. He couldn't even say that it would work in a regular computer. Just, he was able to apply this Enscape software, and basically, he also the information, of course, goes from January 1st to January 28th of 2010, and the file, the initial file that he referred to from that hard drive directory, a loose hard drive, was back in 2008.
Now, the path, though, that a number of these photographs were found under was the same path utilized where there were a number of pictures of the defendant in this case. Now, why isn't that sufficient in terms of knowledge to make this a question of fact for the jury?
Well, they're separate files, and as we stressed in the reply brief, those are separate files where no images were, that he's charged with.
They had pictures of him, hundreds of them.
Correct.
His resume, his divorce judgment, his visitation schedule. I mean, all of these are on that same path.
Well, again, there's the pyramiding of inferences. They're digging up personal documents, and they're leapfrogging to the other files.
If you have an individual who lives in a room and has identification and personal papers in a drawer along with drugs, I mean, that's a pyramiding of inferences just as well.
Well, again, we go back to the supplemental authority and the distinction between 893.13 and 827.0715. Those are two distinct animals of different colors. The legislature has passed legislation after the Bobby Scott case that did not require absolute knowledge of the illicit nature of the substance, and there were presumptions built in. We're talking...
In terms of possession, you still, if you're looking at actual possession and constructive possession, you still have to, demonstrate that, he might not have to know about the nature of the drugs, but he has to have the ability to control and,
Well, that's an interesting point about control. We didn't have control over here. We had numerous equipment, computer equipment found in the garage. He was working on equipment.
He wasn't charged with anything out of the garage.
Well, but we're talking about access and control. And the access and control was...
And the access and control, why isn't that established, at least a question of fact for the jury when, again, all of these, the images are on the same path within the hard drive of the computer as a number of his personal documentation and hundreds of his own pictures?
Well, again, the flyer case does not go to that leap as far as images just recovered
I don't
from...
recall in Flyer that they had evidence of the path that contained personal, information. I think there they were talking about unallocated disk space.
Correct.
But here, you've got more than unallocated disk space. You've got,
That's correct.
Evidence of a specific path that contains the equivalent of personal possessions or images and documents of the defendant.
Well, again, you had multiple people having access to all the computer equipment in that house, period, including the bedroom. And you also have the problem of the personal picture Mr. Long recovered.
What testimony was presented that there was anyone that used this hard drive that was in his drawer, in his room, with the file with his name on it? What evidence was there? I mean, I can understand the other computer or the laptop, but now we're talking specifically about the hard drive. There wasn't any evidence that people were using that, was there?
Well, if you take the defense witness's testimony and you look at it, it is clear that really there was no regulation or rules as to what equipment was...
I thought they basically testified to the computer, to the laptop, that they used it, and that he allowed free access to that. But I have a hard time rationalizing where your argument fits within the record, because I don't recall that there was any testimony. If there was, I overlooked it, about people using a hard drive that was out of the computer, wasn't even in a computer, that was in his drawer.
Well, again, with the loose hard drive, you've got a situation of the possibility of improper scrubbing. We don't know where this came from. The state's case was built.
The defense argument on that was that if this was bought, and we don't know that it was bought at Best Buy, do we?
We don't know really anything.
But but in terms of
Right.
what the defense presented, you're talking about the state's inability to rebut the reasonable hypothesis of innocence. And so if, we don't know if it was bought at Best Buy, but if it was bought at Best Buy, which is totally speculative, and if the prior owner of the hard drive bought at Best Buy had downloaded child pornography, and if it hadn't been improperly scrubbed, then it could be, these images could be contained on a hard drive. That's a reasonable hypothesis of innocence?
The reasonable hypothesis is we don't know exactly what happened with this loose hard drive, or the possibility of malware and rogue computer programs, which Mr. Long testified to both devices, could...
But those won't put them into files,
Not, right.
And here you've got, you've got a determined path, you've got a designated path, and malware and, these pop-ups are not going to place it into files where there are a number of different images.
No, but Mr. Long said it can download programs, rogue programs can download entire files, even if it's not putting the image in a file, okay? So basically, he could not identify the specific attributes of the specific files that contain those images as to when they were created, who they were created, who created them, how they were created, the dates. This just is a case that fell short of the mark of proving each and every one of these counts. You compare the cases that the state tried to rely on, and there is a plethora of more evidence directly attaching the defendant's knowledge of each images he is charged with.
Did you answer your question?
Oh.
Yes. You're well into your rebuttal time.
Thank
You
you.
want to save
Thank
some
you.
time? Sure.
Good morning, or I should say good afternoon. My name is Allison Morris. I represent the state of Florida in this matter. This is the 57 counts of pornography found on 2 of the appellant's computers.
Right, so a lot of these images were found in the unallocated...
Pardon that?
A number of images were in unallocated space.
Right.
Okay, so they had been deleted. Do you think that if that's all you have, that that's sufficient to support a conviction?
I will start by saying, yes, given the circumstances of this case. Flyer was dealing with a hard drive with unallocated spaces that had no additional pornography on it. There was a lot of other evidence related to another computer that he had that was an Apple computer. So in that case, they were just saying that there was no evidence that he actually had ever downloaded the files. They had just been on the unallocated space. There was nothing else showing that he had knowledge of the illicit material on the computer. I also did supplemental authority with Pruitt. The case Flyer is out of the 9th, and actually I think that case is wrong. I think in Pruitt, they looked at all the evidence, all the fact that the defendant had been downloading pornography and used that to show that he had knowledge on the unallocated spaces. Now in our case, we have a variety of evidence coming from that one hard drive. We've got pictures, I think over 200 pictures of the defendant and the unallocated spaces. We've got 3 files with pornography in them that are labeled. We have 2 pictures of the defendant with the GD phone, that would be the file label. And all of this is coming under, and those are actually coming under a very specific line. They start with the computer, the user, the my docs, my pics, and then the files going down. So it shows a clear intent to put these files and save these files. These files just didn't randomly fall in. The pictures didn't randomly fall into the files, and then into the folders. And I think you can use that evidence from that computer to show that he had knowledge of these unallocated files, that he deleted these files. Does that answer your question? Okay. And that was the thing I was going to do, was to distinguish Flyer from my present case and also Pruitt. And a lot of the other, I think, district courts have kind of looking at everything, not just the one file. The other issue I was going to address briefly was the issue of the 6 pictures that they argued were not pornographic in nature, that they were just nude pictures. The statute says that sexual contact can include actual lewd exhibition of the genitals. And those pictures were not just children standing on a beach. The children or child was a young prepubescent male who had body paint on him. And it was definitely a lewd picture. And the judge looked at that picture and agreed that it should go to the jury, and the jury obviously found those to be lewd under the context of sexual conduct. Are there any other questions?
Do you think that the comment where he was asked, do you have any interest in child porn, and he says, not direct, what does that mean?
I believe, well, I think it was a cagey answer is what he was doing. The actual testimony was, he was asked if he had child pornography. He said he might have migrated to some sites that pop up with child pornography. When she asked him if he was interested in it, he replied, not a direct interest. This to me, not a direct interest, which, like I said, it's a cagey answer, and to me that implies he had an interest, and maybe an indirect interest. I think it's a cagey answer saying he had a direct interest. I think that shows knowledge, that he was trying to mince his words, or measure his words, and I think that goes to show knowledge of the fact that he knew he had these illicit images on his computer. Are there any other questions? I will rely on my brief, and I thank the court for its time today.
Thank you. You got a little time left for rebuttal, counsel.
Briefly. None of the statements by the defendant tied directly to specific knowledge of any of these files that contained child pornography. And as far as the Pruitt case is concerned, there is, as appellate counsel for appellee noted, much more evidence there. You had a sophisticated operation by Mr. Pruitt of not downloading it as a work computer, but saving it, it was on the work server. And then he was able to view with his home computer through his own work authorization of HP to view these images and save them in the catch file on his temporary catch file on his home computer. So that the appellant submits is clearly not on a different level of evidence than what we have here. We are solely lacking of evidence, and I'd like to conclude that they noted in Pruitt, prosecutors, judges, and juries have a duty to safeguard as best they are able potential defendants when receipt of child pornography might well have been truly inadvertent as a result of spam or computer viruses. Thank you.
All right, thank you.